Good morning. Thank you all for allowing me to speak. Lord Ogden coined the phrase that says power corrupts, but absolute power corrupts absolutely. And that's what I believe the situation is dealing with returning to the judicial system of the day. So a lot of the living conditions that people are complaining about here in the county jail, and from which I just left, is based on the judicial system. You're overcrowding people. You're piling people on top of people for no apparent reason. I've seen people in here go to 9 different pre-trials. No alleged victim showing up, and so they have to go to 3 trials with no alleged victim showing up before they dismiss a case. But the whole time, they're trying to get the person accused of this crime to take a plea bargain for something they did not commit. And what do you want to do when you're in these conditions? You want to do anything to get out of the way. You want to do anything to, so you take a plea bargain. When I'm talking about Lord Ogden, I say this, a lot of people need to be aware with Title 19 or Title 18 of the USC, Section 1621, concerning neglect to protect a person by under oath and but not limited to. Title 42 USC, Section 1986, where a person having knowledge of the law, the power to stop a wrong, and the duty to prevent a wrong from being done is liable for any failure to act. And I think a lot of the judges need to pay attention to this, and a lot of us need to learn what's going on so we will stop falling for what's being done to us. These are violations of right, the due process of law, violations of double jeopardy. Now, I want to read something that happened to me in particular. I filed a motion to dismiss on the grounds of double jeopardy and cruel and unusual punishment. And I sent this, and I don't mind saying names, I sent this to Judge Ambrose, who's supposed to be so fair. Your Honorable Judge Ambrose denied this motion, spoken about on 1/16/2019, on the grounds that there is no indication that the offense identified in the indictment in the case is the same offense adjudicated by the Cleveland Municipal Court. So I rebutted that with 3. The motion itself, stamped the date of 1/11/2019, is Exhibit B, page 3, paragraph 2, clearly states, the municipal court judge Cassidy erred when she found the accused to be in violation of his community control on hearsay and found him to be guilty before the accused was offered an opportunity to prove his innocence in common police court before the Honorable Judge Dick Ambrose, which contradicts the reason you denied in showing proof of the accused's argument that the violation of this right to be free from cruel and unusual punishment and double jeopardy has been imposed upon him in Judge Cassidy's courtroom for the exact same case of violation of a temporary protection order that is in your courtroom, which make a conviction of any sort in your courtroom triple jeopardy. And further violation of the accused state and federal rules of procedure and state and federal constitution be free from cruel and unusual punishment, double jeopardy, violation of the accused's right to due process of law, but not limited to. What makes this so bad is that I'm one of many, many people that are going through this, and I contacted the media and said, please come in here if they allow you to pick one. Pick a floor from top to bottom, 3 people of each pod, and you'll find the same situation going on that's not being handled and not being taken care of. I just got out of jail February 11th for this, but the killing part is this right here. Let's read this. Furthermore, the accused has spoken of and was proven violation of state and federal rules of procedure, state and federal constitutional violations, code of ethics, and more. And since the accused has been released, he has found more proof that there has been hidden this collusion against him, that this case that I've been convicted on 3 times has been dismissed since August 15, 2016. So I was convicted 3 times for a case that does not even exist. And I've been continuously brought back and forth to court as if the case was alive by those who are supposed to protect me, those who are supposed to be of justice, those who are supposed to abide by the Constitution for the United States of America. And I sent this to my administrative judge early, who did nothing. One of the guys who committed suicide here, I'm a case manager. I talk to him every day. And a few things happen that are beyond you, beyond self, beyond your schooling, beyond what you're able to do. And this man actually committed suicide while he was in our hospital. His mother passed away, and his daughter was molested. And he didn't even take drugs. He wasn't here on drugs. But he said, I would rather die to not see what is continually being taken from me than to see it and depend upon those who are of justice that are doing nothing for me. So this is the problem with the justice system. You have the right to correct a wrong when you see it, and many of you judges are doing nothing. Correct that. abide by the Constitution that you swore over office to abide by.
As you just hearing me speak, that was actually in front of the Administrative Judge Russo, Administrative Judge Early, who I clarified did nothing about the incorrections and the errors, that the violations, code of ethics, violations of the code of ethics, violations of the state and federal constitution, violation of the accused's rights, the due process of law, to be free from cruel and unusual punishment, and things of that nature. You see me talking about it. Now I'm going, from here on out are pages, so I'm going to read this for those of you who choose not to put on pause and read it yourself. So I'm going to read this for you. This is Exhibit A. It's going to actually be, this was used as something else in a whole another process that you'll hear about soon, but you'll see this was filed on March 14th. Filed on March 14th, 2018, right? This is, no, 2019, please forgive me. And you'll see that this is to Judge Dick Ambrose. This is a motion for reconsideration to dismiss on the grounds of double jeopardy and cruel and unusual punishment. Now, the reasons are as follows. In the matter of justice, all accused have the inalienable right to state and federal rules of procedure, and as well as the inalienable right to the state and federal laws of the constitutions, to be faced with all of the evidentiary issues presented against them in a court of law, the right to effective assistance of counsel, due process of law, and but not limited to, the right to be free from cruel and unusual punishment. These are the United States Constitutional Amendments 1, 5, 6, 8, 9, and but not limited to 14, and Ohio Constitutional Articles 1, Sections 1, 2, 5, 9, 10, 16, and 20. Now, Article 1, page 1, it says, the accused filed a motion to dismiss case number CR-18-628340-A on the grounds of double jeopardy and cruel and unusual punishment, being that Judge Cassidy in error violated accused of his community control not once but twice for allegedly catching a new felony, but not limited to. These violations and jail times were imposed upon the accused August 7, 2018, and again on September 10, 2018, for allegedly catching the case CR-18-6283440-A in your courtroom as stated on docket as new felony. See Exhibit A, docket sheet, from dates 8/7/2018 to 9/10/2018. This is Article 2, page 2, same page. Article 2, you, Honorable Judge Ambrose, denied this motion spoken above on 1/16/2019 on the grounds that, and I quote, reading it strictly, there is no indication that the offense identified in the indictment in this case is the same offense adjudicated by the Cleveland Municipal Court. My rebuttal in Part 3 is, the motion itself stamped and dated 1/11/2019 as Exhibits B, page 3, paragraph 2 clearly states, the Municipal Court Judge Cassidy erred when she found the accused to be in violation of his community control on hearsay and found him to be guilty before the accused was offered an opportunity to prove his innocence in common pleas court before the Honorable Judge Dick Ambrose for the case, which contradicts the reasons for, page 2, your denial in showing proof of the accused's argument that the violation of his right to be free from cruel and unusual punishment and double jeopardy has been imposed upon him in Judge Cassidy's courtroom for the exact same case of violation of a temporary protection order that is in your courtroom, which would make a conviction of any sort in your courtroom triple jeopardy. And further violation of the accused state and federal rules of procedure and state and federal constitution to be free from cruel and unusual punishment. Double jeopardy, violation of the accused's right to due process of law, but not limited to. Article 4. Furthermore, more proof to substantiate the contradiction that there is no proof that the case in your courtroom, Honorable Judge Ambrose, is the same case that the accused has been adjudicated on in municipal court is that according to docket Exhibit C, JE, which means journal entry, 10, date 10/22/2018, when R.J. Budway was counsel for the accused was brought into your courtroom, Honorable Judge Ambrose, and a deal was presented to the accused on record stating that the same violation of the temporary protection order with the same case in reasonable violation in Judge Cassidy's courtroom, and the time would be conjoined and or ran concurrent if the accused took the deal in your courtroom presented by your prosecutor and my counsel that you granted my oral motion to dismiss for him even bringing it up and not filing the motion to dismiss nor fighting it, among other violations. See Exhibit C. Article 5. Furthermore, the accused is spoken of and has proven violation of the state and federal rules of procedure, state and federal constitutional violations, code of ethics, and more. And since the accused has been released, he has found more proof that has been hidden in this collusion against him in this case that has been dismissed since August 15, 2016. Article 6. This means that as the accused has stated in motions on public record that Judge Cassidy, her bailiff, her prosecutor, and two of the counsel concerning the case mentioned above have all been in a conspiracy with a malicious intent to assassinate and defame the character of a productive citizen in our society to assist their friend who is the alleged victim on the very case that they preside over through the process of violations of the Fifth Amendment, of one's right to due process of law, and through the criminal violations of fraud, but not limited to. Since this case was dismissed August 15, 2016, they produced fraudulent paperwork to even bring accused to court, then to sentence accused to a manipulated and fraudulent plea for probation, to violate accused on that same fraudulent probation twice for the alleged new felony in your courtroom, Honorable Judge Ambrose, that even allowed the accused to be in your courtroom as a felony. All on fraud. Since this case was dismissed, the case that is now in your courtroom as a felony, Judge Ambrose, would still be a misdemeanor and not a felony at all. See Exhibit D, certified copy of NALI of temporary protection order concerning the case in your courtroom, Honorable Judge Ambrose, so only be in there on your courtroom on the grounds of fraud. Please see Exhibit D. Article 7, page 3. Furthermore, in your courtroom on the above mentioned date, 10/22/2018, I ask you, Honorable Judge Ambrose, do you know that I have never been served a temporary protection order? You said no. I tried to show you the unsigned protection order. You denied me from doing so. The prosecution never mentioned but still tried to get the accused to take a plea bargain, which gives the accused the perception that the prosecution has not presented all of the evidence to the court, including but not limited to the NALI of this very case in Judge Cassidy's courtroom that allows the same violation to be a felony in your courtroom, again on the grounds of fraud. 7. Furthermore, in your courtroom on the above mentioned date, 10/22/2018, the accused asked you, Honorable Judge Ambrose, do you know that I have never been served a temporary protection order? You, Judge Ambrose, said no. The accused tried to show you the unsigned protection order. You denied him from doing so. The prosecution never mentioned but still tried to get the accused to take a plea bargain, which gives the accused the perception that the prosecution has never presented all of the evidence to the court, including but not limited to the NALI of this very case in Judge Cassidy's courtroom that allows the same violation to be a felony in your courtroom. This is a violation of the Brady Act, Brady v. Maryland, 373 U.S. 83, 1963. You'll see that the conclusion of this is ceased. The conclusion is the accused is being asked that this case needs to be dismissed. Yet it still continues. You'll see on this case right here, on this page, this is the exhibits. This is Exhibit A. When you see Exhibit A, you'll see that there's a box on here. You see that box? And you'll see that the accused was brought to court and the community control, the probation officer was asked to be there, but denied to be there because she did not want to be a part of the collusion and the corruption and the fraud that was going on. You'll see that on 8/7/2018, you'll see it right up at the top, as soon as the line starts, you'll see that the accused was given 20 days, but was never found guilty on the case on a new felony. So, going through, the accused was found out that the Judge Cassidy's bailiff, Emily Grantones, you know what I'm saying, was actually went to school or something like that with the alleged accused ex-wife. So they were manipulating situations on this. So I found this out, and I wrote the judge, and I told the judge, hey, if you continue with this case, this is an ethical violation, but you continue being that your friend, your bailiff, is friends with the ex-wife. And they brought me back to court. You will see it on 8/21/2018. And when I got into court, they were quiet. They weren't saying anything. And I said, well, listen, are you going to release me? Are you going to let me go? I said, well, listen, I mean, did you get the letter? And when I asked, did they get the letter? So this would not be presented in public. The judge actually shut the court down, shut the video off, and sent me back. And you will see here, like when you go 8 sections down from the first one on 8/7/2018, you go 1, 2, 3, 4, 5, 6, 7, 8. You will see here. Remember, I'm asking, can I get out? But you will see here that the judge actually put on the paperwork that I asked for a continuance, not to be released, but that I asked for a continuance to go back to jail and finish my jail time when I'm in here innocently, knowing that I did nothing at all. This is the fraud that's going on down here by a judge. Now, after this comes out, you will see that I actually came back. I was released on August 27th, I believe it was. I was released on August 27th, and I was brought back 10 days later, or 13 days later. I was brought back 13 days later on 9/10/2018, and given the rest of the 6 months, the 154 days that was left in the 6 months on a case that doesn't even exist. It's all on docket. This is something they don't believe that a black man is supposed to do. Know what's going on. When you look at this, you'll see Exhibit B that I'm talking about. This is the original motion that I sent in, right? You'll see the filing date on there, and I state the dates and the times on there. This is a motion to dismiss. This goes to Judge Dick Ambrose, and you'll see on there page 3, 1, 2. Page 3, paragraph 2, and it states, what is clear from the record in Muni Court is there was no proof at all that the accused violated his community control on anything other than hearsay. The municipal court trial Cassidy erred when she found the accused to be in violation of his community control on hearsay and found him to be guilty before the accused was offered an opportunity to prove his innocence in common pleas court before the Honorable Judge Dick Ambrose for the case. Right there. Now, how can he say that there's no way that he can tell? Let's go back. How can he say there's no indication that the offense identified in the indictment in this case is the same offense adjudicated by the Cleveland Municipal Court? I stated in the motion that he denied. It's on a journal entry, right? Didn't I show you the docket sheet that he also has? That he refused to show and refused to do anything about? Right? Now, let's get to this last part. When he said there's no proof that it's the same, right? When you go to journal entry, J10/22/2018, right? And you see what it says? I'm going to read it to you. Defendant in court, Counsel R.J. Budway present. Prosecutors Jillian Snyder present. Court reporter present. Case called for trial. Plea offered. The plea was offered, placed on record. Defendant makes oral motion for new counsel. Motion granted. Court assigned Edward Hendel. Now, how can he say it's not the same case? When he told me that the plea was offered that I just told you was offered. They told me the same case that was in Judge Cassidy's courtroom is the same case that was here. And if I took the plea bargain, I would get time served. They would run it all concurrent. But I won't admit to guilt on it. Right? For this final piece, concerning just that motion is this right here. Turn the light up a little bit. You'll see this on there. On your paper, it might be in reverse, but right here, you'll see that this is a certified copy. This is February 27, 2019. You will see right here that this has actually been signed by the judge or magistrate. This was given to my counsel, Kalita Sims, because it was nollied by the grand jury. This means dismissed. See the date here is August 15th, 2016. Yet, my counsel that I had at the time, Kalita Sims, nor the judge, Cassidy, the prosecutor, none of them explained anything to me that my case was dismissed. But in order to move forward, I just got a scholarship. I went and got my license to be a case manager. And an organization saw that I did good, felt that I did good enough to where they said, man, you need to start your own practice. So they gave me a full ride and a scholarship for psychology. So I'm explaining to my counsel and the judge, listen, I just want to move forward with my life. I didn't do none of this. I'm never going to see her again. I'm good. I'm all right. I just want to move forward. Let's keep going. She can do her and I'm going to do me. So they told me they would give me time served for this felony. They told me they would give me time served for it. So I copped to get time served, but because on a scholarship, you can't have an open case and you cannot be on probation. At this time, I still don't know nothing about my ex being friends with the judges and the bailiffs and that they're manipulating. All. I don't know none of this right now. I just want to move forward with my life. So I take the plea bargain, time served. But when I get in the courtroom, Judge Cassidy gives me 2 years probation. That kills me from being able to register as a case manager now, and that killed the scholarship for psychology to go and start my own practice. None of them told me what was going on. So they gave me 2 years paper. In the process of the 2 years paper, they violated me 2 more times for violations of a temporary protection order that I never did. All out of anger. Again, look at the case. You will see what's going on. So people talk about the living conditions of the county jail. It's not the living conditions. The living conditions, I'm going to say this. The living conditions are where they are because the judicial system is still corrupt. It didn't end with Jimmy DeMore. It changed faces and names, and now they got to the degree to where, guess what? They feel that they can do what they want to do. As stated in the beginning article, what did I say? Lord Ogden coined a phrase that says power corrupts, but absolute power corrupts absolutely. And until you find out what they're doing and see what they're doing and find out and be able to take their immunity with Title 18 and Title 42 of the USC, they'll continue to do what they do. So I want to expose this and get this out because guess what? I'm not the only one. Strength is in numbers, especially when it is of quality of the quantity. You see what I'm saying? We got to do this right. Let it do everything it is that they're doing in the process of the Constitution that they're not doing. Take care. This is also so nothing will be lost in translation. This is one of the motions that I filed to Dick Ambrose. And you'll see it was stamped and dated on the 31st. And also in March. And this is a motion. This is a motion for clarification from Counsel. His name at that time was Jen DeCaris. Jen M. DeCaris to client. And I'm asking for information that somebody's giving me. This is actually my 7th attorney. I went through paid attorneys and court-appointed counsel, and none of them will actually answer the questions that I'm asking them. So I sent this to the courts and forced the courts to tell me, to give me clarification of what's going on in court. So I'm going to read this to you. And the reason for this motion is, as stated in each article listed below, the accused is being violated in each of the constitutional rights listed but not limited to, and by the courts, and is asking court-appointed counsel to clarify to accused in writing why GNM DeCaris says the opposite of each violation accused is stating and has shown by Supreme Court case law is being imposed upon accused. Yet again, GNM DeCaris does not choose to fight these violations and says that they are not violations at all. Since accused has been denied from going to counsel's office and can only see him in court and spoken to verbally, and accused is being denied the right of the First Amendment of the Constitution by the counsel appointed to him by the court. Accused is therefore demanding the court to demand that the grounds for this motion and notice to be met as required by accused. This is what I'm asking. Listen to this. I, Maurice of the Marbury family, in whom you have been appointed counsel for concerning case number CR-18-628-340-A in the courtroom of Dick Ambrose. 2. You, GNM DeCaris, have told accused verbally that there was no double jeopardy in the initial case of 2015 CRB 026602, as in the same case with 2015 CRB 026606 in Muni Court that caused this same case in violation to be a felony in Dick Ambrose courtroom. Please explain on paper, not verbally, and in at least 2 case laws of the Supreme Court, so there will be no loss in translation nor definition to show that what you are saying is true and by law, and that contradicts Ohio versus Eugene Marks 2015, Ohio-4179, to where accused was sentenced to not once, but 3 times on a case that was dismissed a month earlier. 3. You, Mr. Jen M. DeCaris, said that what Marilyn B. Cassidy did in sentencing the accused twice for the same case that is now in Dick Ambrose's room is not double jeopardy, and therefore would not be another violation of accused right to be free from double jeopardy, cruel and unusual punishment, and a triple jeopardy if found guilty in Dick Ambrose's courtroom. Please explain on paper and in at least 2 case laws of Supreme Court, not verbally, so there will be no loss in translations nor definitions to show that what you are saying is true and by law, and that contradicts Ohio versus Eugene Marks 2015, Ohio-4179. You, Mr. GM DeCaris, said that accused had 2 separate cases in Marilyn B. Cassidy courtroom, and that one was dismissed when accused agreed to the manipulated plea bargain. Could you please explain this again, and by show of court docket on paper, not verbally, and in at least 2 case laws of Supreme Court, so there will be no loss in the translation nor definition, and that the case was dismissed August 15, 2016, but accused was not manipulated to take the plea bargain until a month later in September of 2016. Your timing does not add up, sir. 5. You, Mr. GM DeCaris, continue to call accused in voicemail or in person at court, but have denied accused from coming to your office. As you have stated to accused, I have so many clients, which only allows you to see accused in court without ever being able to sit down to plan a strategy to fight the fraudulent cases presented against the accused and to thoroughly examine all of the evidence accused has to prove his innocence. This is actually ineffective assistance of counsel. Accused can only see you in court and is grounds to be dismissed as ineffective assistance of counsel. as well. 6. You, J&M DeCaris, have yet to fight the motion for reconsideration to dismiss due to double jeopardy and cruel and unusual punishment that contradicts Dick Ambrose's reason for dismissing of the initial motion. Please explain on paper and in at least 2 case laws of the Supreme Court so there will be no loss in translation, nor definition to show that what you are saying is true and by law. See Exhibit A, motion for reconsideration to dismiss on grounds of double jeopardy and cruel and unusual punishment, including the original motion to dismiss that was denied, the docket sheet, and certified copy of the case as being nolly. 7. You, J.M. DeCaris and Dick Ambrose fear being recorded by accused and state that accused nor anyone in the court to witness for accused can record. You and Dick Ambrose state that it is a violation of client counsel rights and privileges. Please explain why you both fear being recorded if your aim is for the justice to be done, even according to accused. The accused has nothing to hide. You, Mr. J.M. DeCaris, and Dick Ambrose are not lying, nor violating the accused rights, and are abiding by your oaths of office, your performance bonds, and the Constitution for the United States of America, which is the supreme law of the land, which also entails the right to freedom of press and the business of accused as press. Please explain on paper and in at least 2 case laws of Supreme Court so there will be no loss in translation nor definition to show that what you are saying is true and by law, contradicts the Constitution and the rights of the accused. See Exhibit B, Articles of Organization for a Domestic Limited Liability Company, with one of its purposes being media, press. Since no law can contradict the Constitution, you, Jim DeCaris, and Dick Ambrose are continuous violations of the First Amendment of the Constitution for the United States of America, and that Free Press Clause protects publications and information and opinions and applies to a wide variety of media. In Neer versus Minnesota, 1931, and New York Times versus United States, 1971. The Supreme Court ruled that the First Amendment protected against prior restraint, pre-publication, censorship in almost all cases. The Petition Clause protects the right to petition all branches and agencies of government for action, in addition to the right of assembly guaranteed by this clause. The court has also ruled that the amendment implicitly protects freedom of association. 8. The accused spoke with you over the phone on this 22nd day of May in the year of our Lord, 2019, at or about 1:25 p.m. when accused asked you, Mr. Jim DeCaris, about the motion for reconsideration to dismiss on the grounds of double jeopardy and cruel and unusual punishment. You stated that this motion should not be heard because accused wrote the motion, and that Dick Ambrose said that it would not be answered and that you do not desire to fight it. That was never mentioned on the record by Dick Ambrose. You may, however, deny to fight it, which substantiates your ineffective assistance as counsel and part of your collusion. Again, please explain on paper and at least 2 case laws of the Supreme Court so there will be no loss in translation nor definition, and produce the tape recorded in court that states this, and or the transcript. 9. Jim DeCaris, you have been told by the accused that he has never received a protection order. Yet you, Jim DeCaris, have not one time spoken about how accused rights of this denial of accused right to due process of law has been violated, nor have you spoken about fighting it nor for it. As the paperwork has been manipulated, as spoken about in Article 2 of this notice, even if they can produce the paperwork with a forged signature of accused on it and the accused right to due process of law was denied, according to Ohio Revised Code 2919.26 and 3113.31, and that if the court issues a temporary protection order under this section as an ex parte order, it should conduct as soon as possible after issuance of the order a full hearing in the presence of the alleged offender, not later than the next day on which the court is scheduled to conduct business, after the day on which the alleged offender was arrested or the time of the appearance of the alleged offender, pursuant to summons to determine whether the order should remain in effect, be modified, or revoked. The hearing should be conducted under the standards set forth in Division C of this section, Articles D1 to B, Titles 27 through 41 of both Ohio Revised Codes. This right of accused was also denied and violated. Yet you, J&M DeCaris, do not speak of any of these violations but still desire to go to trial. Why? Again, please explain these things to accused in writing, not verbally, so there will be no loss in translation or definition, and with at least 2 Supreme Court case laws that will contradict this to show that what you are saying to me is truth and by law. You will see it as an thing is documented, and you'll see this notarized. You see the paperwork there, and guess what you'll see? You'll see my articles of incorporation of a limited liability company, Mo Better Publishing Productions LLC, which is actually media and press. So how are they denying me to do anything in the courtroom? Again, unless they are lying. This is, I'm actually on my 8th attorney through the process of paid attorneys and court-appointed counsel who all quit my case. They all quit, and or I have to fire them for ineffective assistance of counsel because these are the questions that I'm asking. These are the questions that I'm asking. Again, you will see this in Article 2 of the affidavit, like I said, or the motion, like I said. UGM declares have told accused verbally that there was no double jeopardy in the initial case of 2015 CRB 026602, as in the same with 2015 CRB 026606. Now, what you will see is this. This is the fraud and the manipulation. I say that y'all seen it before. The initial case was signed by the judge, given to my counsel at the time, and it was nollied by the grand jury, right? Let me see the case number on here. This is the exact same case number, the exact same ticket. However, when they find out that they are alleged okay, they are okay with the alleged victim. Same case number, same absolutely everything. What they did was created fraudulent paperwork to bring me back and forth to court like the case was live and convicted me 3 times for a case that does not exist. This is why the counsel keep quitting. This is why my case has been lasting going on almost 4 years now, because I would not cop a plea to what's going on, because I continuously demand that my attorneys ask the questions that I'm asking them to be asked in court. This is what's going on right here. And again, it's not just the living conditions of the situations down there. I blame the COs for what's going on, but at the same time, I blame the judicial system for compiling people on top of people like sardines in a can, because they get a percentage of every time they convict somebody. They get a percent. That's how they stay on. In order for them to say, "Oh, I hate crime and I hate justice," I keep convicting people. What we as a people never do is find out if these people are really innocent or not. And you don't feel it's up to you to do that when it is. So this is why we are going through the situations we're going through, and this is why I'm dealing with what I'm dealing with. And I'm one of the hundreds that go through this a day. Stand up and help us. This is an excerpt from my book, copyrighted in 1998. Because I've been experiencing these type of situations. I've lived with people who have experienced what I'm dealing with now. So my situation is, this is just one person. I'm giving you experience that I've been through, but this is not an isolated incident. This excerpt from my book, Isolated Thoughts from the Mind of a Convict. This piece is called The System That Betrays You. There are many causes to the defects of why many others and myself committed some of the crimes we did. Some of us committed crimes that situations in our lives merited, and some of our lives were forced upon us by societies. However, some of us are just bad people. But am I a bad person? Because theft and narcotic sales were my only trades when my teachers were pimps and pushers. Do you blame me or my teachers? If reared from infancy to dance as the gazelle does and to speak as elegantly as kings and queens of those of prominence, would not my teachers be credited as well? If so, then let there not be a turning of the shadow in instances. A boy is reared and becomes the man he was taught to be in a society, established by a society. Because of the causes he was taught by, the effects give him the label criminal, from the very ones who initiate his outcome. Not really a bad person, but one who has been reared and trained wrongly, never has the initiations of his actions questioned, but is sent to a place that a higher society calls correction, for the effects of the reactions they look for and caused. Thousands of times a day, this not really bad, but person who may really have just been made a mistake or bad choice by doing what he was taught is placed in an environment that he is told will help him, and that the media portrays as heaven after sin. In this environment, this person who the majority of the time only made the mistake of becoming a product and or victim of the environment he was placed in is exposed to some of the worst atrocities of human barbarism ever performed on the planet, forcing this possible once kind and misled heart to become calloused and hold malice with the forthright, maybe even as your next door neighbor, but manufactured straight from the system that betrays you.